Protection and Environmental Defense Canada, Inc., Ms. Wilson and Ms. McClenaghan.
Thank you very much. We're going to present two arguments today. I'm going to present the argument that the Act can be upheld under the criminal law power in approximately 9 minutes, and then I'll turn it over to my colleague, Ms. McClenaghan, who's going to argue that Part 2 of the Act can be upheld under the trade and commerce power. I'm going to look at three issues. The first is how federalism should be understood in the context of the criminal law power. Second, I'll look at the first branch of the criminal law test and submit that this Act has a valid criminal law purpose. And finally, I'll look at the second branch of the criminal law test and submit that the Act has the necessary prohibitions and penalties. In my oral submissions, I won't be dealing with the final branch of the criminal law test, which is that the Act can't be colorable, and ask you to look at our factum of paragraphs 21 to 25 for that argument. The focus on day one of this hearing was about concerns about this Act encroaching on provincial jurisdiction to act on greenhouse gas emissions. That's important, but we offer two responses. The first is that the balance of federalism is not served by minimizing or severely restricting the role of the federal government to act on this issue. In Hydro-Quebec, at tab 2 of our Book of Authorities, paragraph 154, the court held that they had equal concern with interpreting the Constitution in a way that effectively allocated control over the environment to the provinces. The federal government needs to be able to play the leadership role expected of it in the international community. Climate change is such a vast, complex problem. It's truly necessary for all jurisdictions, federal, provincial, First Nations, to be able to attack the problem from their spheres of jurisdiction. The corollary to this is that there's no right for the provinces to choose not to cooperate with the carbon pricing regime. In the firearms reference at tab 3 of our Book of Authorities, paragraph 52, the Supreme Court found that the most important jurisdictional effect of the law to create a gun registry was to deprive the provinces of the ability to choose not to have a gun registry. The provinces argued that it was in their power to choose whether or not to have one, and the court rejected that argument. The registry was valid criminal law, and the provinces didn't get a veto over the federal government's policy choice. Our second response to the issues raised about the concerns of federalism and the balance of powers is that in Hydro-Quebec, again at tab 2 of our Book of Authorities, paragraph 131, in no uncertain terms, the Supreme Court held that use of the federal criminal law power in no way precludes the provinces from acting under Section 92 jurisdiction to regulate pollution, either independently or to supplement federal action. I'm going to move now to my second argument, which is the first branch of the criminal law test, and submit that this Act has a valid criminal law purpose. Hydro-Quebec found, again, it's at tab 2 of our Book of Authorities, and at paragraph 123, that pollution is an evil that Parliament can seek to suppress through the criminal law power. That case dealt with the Canadian Environmental Protection Act. It was upheld as valid criminal law, and that act deals with the control of toxic substances. That case dealt with PCBs, but greenhouse gases are also listed as toxic substances in Schedule 1 of CELA. In the Syncrude case, at tab 8 of our Book of Authorities, the Federal Court of Appeal examined the constitutionality of a regulation under the Canadian Environmental Protection Act which would require 2% of diesel fuel to have a renewable fuel content. The purpose of that regulation was to lower greenhouse gas emissions. At paragraph 62, the court held that it was uncontroverted that greenhouse gases are harmful to both health and the environment, and as such are an evil that justifies the use of the criminal law power. I expect that my friends will argue that the assisted human reproduction reference found at tab 10 of our Book of Authorities and the Genetic Non-Discrimination Act reference at tab 10 of Saskatchewan's Supplemental Book of Authorities apply to this case. Those cases are readily distinguishable because both of those cases involved legislation dealing with medical technologies that were not considered to be an evil. They were actually medical technologies that Parliament wanted to promote. And court found that because of that, there was no valid underlying criminal law purpose. It's clear here, based on the evidence in the record, including the IPCC report found in Exhibit D to the Moffat Affidavit, the Attorney General of Canada's record, Volume 1, Tab 1, and based on the findings in Hydro-Quebec and Syncrude, that greenhouse gases are an evil that can be addressed through the criminal law. Finally, I'm going to move to the last argument I'd like to make today, that this Act contains prohibitions and penalties, Branch 2 of the criminal law test. The means chosen by Parliament in this case to address climate change is a carbon pricing regime. The prohibitions and penalties in this Act are grouped into two categories. There's offenses and supporting penalties that ensure the integrity of the pricing regime. And then there's offenses and penalties that ensure that the appropriate charge is paid. In Part 1 of the Act, the offenses relating to the integrity of the pricing system include offenses for instance, failing to file a return, failing to register, making false or misleading statements. The penalties are fines, imprisonment, or both, and those can be found at subdivision I and J of Part 1 of the Act, sections 123 to 133. In Part 2, there's similar offenses created, for instance, for knowingly making false statements, knowingly obstructing an enforcement officer. The penalties are fines, and those are found in Division 4, sections 232 and 233 of the Act. In the second category, offenses relating to paying the appropriate charge, in Part 1, Section 135 creates an offense for intentionally failing to pay a charge, and Section 136 creates an offense for failing to comply with any provision in Part 1. Both of those sections are backed by fines, imprisonment, or both. And in Part 2, Section 240 creates an offense for each ton of carbon dioxide emissions, carbon dioxide equivalent emissions over the applicable emissions limit. And Section 233, sub 5, requires compensation for excess emissions along with any other penalties.
Are you saying it's an offense to emit beyond the prescribed limit?
Yes, that's right. Section 240.
I'd be surprised if
Without
that's the case.
paying, sorry. So,
Without paying.
right, without paying the charge. Yes. Yes. Without complying. So in Part 2, the compliance can either be paying the charge or acquiring compliance units from another emitter. Complex regulatory regimes are regularly upheld under the criminal law power, as long as they're backed by prohibitions and penalties. I'll leave the court with one example, but I also commend the cases that my friend from the Canadian Public Health Association mentioned, R.J.R. MacDonald and Syncrude. And I'll look at the scheme in Hydro-Quebec. which again is at tab 2 of our Book of Authorities. The complex regime in that case was to control toxic substances, and the regime involved identifying, testing, and assessing chemicals of concern, and then placing them on a list of toxic substances. Once they were placed on that list, you could create regulations which could control the quantity and control of releases, where the substances may be released, the manner and condition of releases. And that regime was also a backstop regime. At Section 35 sub 2, sub 5, and sub 6 of CEPA, and you can find that section reproduced at page 230 of Hydro-Quebec, the toxics regime was not to apply where there were equivalent provincial provisions. In paragraph 153, the court held that this approach showed that the federal government was alive to the need for cooperation and coordination. All of that was backed by prohibitions and penalties and upheld as valid criminal law.
My lords, my ladies, trade and commerce is dealt with in our factum at pages 11 to 15. We submit that the federal trade and commerce power under section 91(2) underpins constitutional authority for Part 2 of the Act. Part 2, which begins at section 169 of the Act, is specifically aimed to minimize competitiveness risks for emissions-intensive, trade-exposed industrial facilities while retaining the carbon price signal and incentive to reduce greenhouse gas emissions. That statement is found in a number of places in the evidence, but an example is at the Moffat Affidavit, Exhibit T, page 1. By pricing excess emissions and by allowing interprovincial and national trading of surplus compliance units by those who emit less than their industrial sector limit, and providing for a national market, the federal government has established a system that fits squarely within the trade and commerce power, as Ms. DeMarco outlined yesterday. Of the 5 factors outlined by the Supreme Court in General Motors, found at tab 14 of our Book of Authorities, I will focus our remaining time on the 3rd factor, namely that the legislation is concerned with trade as a whole rather than with a particular industry. In the Moffat Affidavit at Exhibit W, we see that large industries are assigned compliance units pegged to 80% or 90% of their sectoral average emissions. The Canada-wide compliance trading market will allow the capped emitters who don't need all of their compliance units in a given year to sell them to other capped emitters who do. This facilitates emissions reductions at an efficient cost, and either way, once used for compliance, those compliance units must be retired by the minister according to section 179 of the Act. This will reduce the number of compliance units available from past years over time. Maintaining competitiveness of large emitters is key to the system's design in Part 2, and the material provided in the Attorney General record includes in Mr. Goodlet's affidavit, Volume 3, Tab 3, page 3, the fact that his division specifically examined Canadian sectors in order to minimize competitiveness impacts and carbon leakage under the output-based pricing system. Mr. Moffat's affidavit similarly stated at tab W that Part 2 is for industrial facilities that are emissions intensive and trade exposed. It seeks to ensure, Part 2 seeks to ensure that they will not suffer significant loss of market share to jurisdictions who don't price carbon. It was based on this analysis that the emissions limits were adjusted from the originally anticipated 70% to the now proposed 80 and 90% limits. Part 2 was designed to minimize a systemic risk, that of loss of industrial competitiveness and loss of market share due to leakage. It also makes any provincial carbon pricing systems, including Saskatchewan's provincial Ontario OBPS, more effective by ensuring action in all regions of Canada. Recognizing provincial systems such as Saskatchewan's in the scheme also allows provincial flexibility. Here, under the Act, the Part 2 scope is analogous to the federal competition legislation that was the subject of the 1989 General Motors case, which I referred you to in our Book of Authorities. And if you look at page 678 of that case, the court noted that the deleterious effects of anti-competitiveness practices transcend provincial boundaries. Competition is not an issue of purely local concern, but one of crucial importance for the national economy. Both General Motors and the November Pansecurities case, which reviewed it, said that the legislation was aimed at stamping out risks and practices unhealthy to the Canadian economy. Likewise here, in conclusion, Part 2 of the Act is aimed at reducing large industry greenhouse gas emissions across Canada while protecting the competitiveness of these trade-exposed industries and giving them time to adjust while retaining the carbon price signal and the incentive to reduce emissions. The analysis in General Motors and Pan-Canadian Securities is directly on point. Subject to any questions, the Canadian Environmental Law Association and Environmental Defence thanks you for the opportunity to provide these submissions today.
Thank you, Ms. McClenaghan, and to you, Ms. Wilson. I think we'll hear Assembly of First Nations, and then it might be an appropriate time for our